Thank you very much, Natalie, for that kind introduction. I appreciate the opportunity to speak here at the Hinckley Institute of Politics. As an aside, I have to note at the outset that it's kind of a bittersweet moment, because my understanding is that this is perhaps the last time I'll be able to stand in this room, last of many times that I will have stood here, because they'll be saying goodbye to this space. So we wish you well in your new quarters, but we'll miss Orson Spencer Hall. Regarding today, it's a real honor to be here with Representative Mia Love, who is a good friend of mine and also an ally of mine in Congress. We're here today to introduce the Article 1 project to Utah. I also want to thank my friend Stephen Moore, who's the chief economist at the Heritage Foundation, for being here with us today, and I look forward to some additional events this afternoon where he and I will continue to discuss the Article 1 project with Utahns. To put it as simply as possible, the Article 1 project is a network of House and Senate lawmakers working together on a new agenda of government reform and of congressional rehabilitation. The entire premise of the Article 1 project is a simple thing. It's a simple idea that the federal government is broken. At least it's not working in an optimal fashion, and congressional weakness is to blame. I don't mean accidental congressional weakness. I mean very deliberate congressional weakness, and I'll explain that now. At a time in Washington, when our government in Washington is held in such low regard by Americans of all political and ideological stripes, it may sound bizarre to talk about the need to re-empower Congress, which is itself one of the most distrusted institutions in our entire country. And in fact, as I like to point out, that Congress tends to poll right around 10%, which makes us only a little less popular than Raul Castro is in America, and only slightly more popular than the influenza virus, but the virus is always gaining ground on us. But I would argue that Congress is broken, and that Congress is very unpopular, because it has chosen very deliberately to make itself weak. The authors of the Constitution went out of their way to make certain that Congress would be the most powerful of the three co-equal branches of the federal government. Congress, for that very reason, was designed not only to be the most powerful, but because it was going to be the most powerful, to be the most accountable of the three co-equal branches of government, in that it would be accountable to the people at regular intervals, every 2 years in the case of representatives, every 6 years in the case of members of the Senate. Consent of the governed in any republic depends on a type of transparent lawmaking process within representative institutions. Congress's embrace of this mandate is part of what has made America successful. But if there's one thing that politicians of every party and every ideological background tend to agree upon, it's that hard work and the type of accountability that go along with the legislative process are inconvenient, and they can make the Holy Grail of so many politicians almost unattainable. That Holy Grail meaning avoiding criticism, avoiding accountability for laws that are put into place. And so over the course of the 20th century and accelerating into the 21st century so far, Congress has deliberately handed many of its constitutional responsibilities over to the executive branch, lock, stock, and barrel, just saying, you take it, you exercise it, you take it from here. Increasingly harmful federal laws are written by people who never stand for election, by means of processes that are contrary to those envisioned by the Constitution and created by the Constitution, and indeed contrary to and in conflict with the explicit purpose of excluding the American people from the process of making law and the process of establishing policy, and insulating that from popular accountability. Executive overreach is an enormous problem. But sometimes when executive overreach is discussed, it is referenced, at least by members of Congress, as a situation that occurs that involves Congress as the victim. Congress isn't the victim here. Congress is the perpetrator. This is a problem, in other words, of Congress's own making. Under houses and senates and presidents of every partisan combination imaginable, Congress has recast itself as sort of the backseat driver of our federal government's processes. Today, upwards of 95% of federal laws, depending on how you measure them, are passed not by the House and the Senate and signed into law by the President as contemplated under Article 1, Section 7 of the Constitution. They are instead imposed unilaterally by unelected bureaucrats. Now, these unelected bureaucrats, I want to make very clear, are themselves not the source of the problem. And in fact, the unelected bureaucrats themselves, by and large, are hardworking, well-intentioned, well-educated, and highly specialized men and women. They're just doing their job. Again, they're not the perpetrators. Congress is the creator of this problem. At the same time, Congress's budget process has almost entirely broken down. Most federal spending has essentially been put on autopilot, authorized without a vote. Meanwhile, fiscal oversight and deliberation and reform are something of a bipartisan charade. And by that I mean that Democrats and Republicans in Congress have made it a charade over the course of many decades, regardless of who holds the majority at the time. This sort of upending of our constitutional order has led not only to bad policy, but to deep public distrust of our governing institutions. This dysfunction is a large and a growing problem for the American public. And for those of us who consider ourselves conservatives, it represents something like a crisis for at least two reasons. First, conservatives believe in constitutionalism and in the rule of law as such, as bulwarks of freedom and justice in our society. And second, the transfer of lawmaking power from Congress to the executive branch tilts the playing field, rigging the lawmaking process to benefit the wealthy and the well-connected at everyone else's expense. When elected representatives in Congress tie their own hands and empower unelected bureaucrats to make the laws, it thwarts the kinds of policies that conservatives tend to advocate. That is, policies that limit the size and the scope and the reach of the federal government and protect the rights and the opportunity of all Americans. So it's no wonder that Congress's approval levels are at an all-time historic low. In many ways, we're not even doing our job as an institution. And the nation is paying a heavy price for that. But there is good news. What a weak Congress has broken and weakened, a strong Congress, a reformed Congress, can fix and reform. The constitutional powers necessary to put representative accountable government back to work for the American people are still right there in Article 1, ready to be reasserted. And that is exactly why we started the Article 1 project, and that's why we call it the Article 1 project. The purpose of the project is to develop, advance, and ultimately enact an agenda of structural reforms to strengthen Congress by allowing Congress to reclaim its constitutional legislative powers that today and over the course of several decades have been improperly exercised by the executive branch by operation of these many, many delegations of power. Specifically, A1P, as we call it, will focus on restoring congressional power in four key areas that are at the core of Washington, D.C.'s broken status quo. The first area involves reclaiming Congress's power of the purse. Second, reforming legislative cliffs. Third, reasserting congressional authority over regulations and regulators. And finally, curbing executive discretion. Just last week, I joined a group of 10 senators, including Senator Orrin Hatch, and a group of 46 representatives, including Congresswoman Mia Love, to introduce the Separation of Powers Restoration Act. Our bill would empower courts to provide a lost check on executive power and begin to force Congress to start doing its own work again, to start actually making law again and being held accountable for making law. Now, it's always dangerous, always, whenever Congress gives away its legislative power, its power to make law, and just hands it over to somebody else in the executive branch. But that danger, which had existed for several decades already by the mid-'80s, got that much more potent in 1984 when the Supreme Court decided a case called Chevron versus Natural Resources Defense Council. In that case, the Supreme Court of the United States held that federal courts must defer to federal regulators' interpretations of a law, so long as the regulatory body in question provided a permissible construction of the statute. Basically saying, once Congress passes a law, we hand that law over to the agency, and that agency is in charge not only of implementing that law, of executing it, of enforcing it, but they also get to decide what it means. And the courts pretty much have to follow whatever the agency itself says that the law means. Whatever speculative value this so-called Chevron Deference standard may have had in theory at its outset, at the time this case was decided, in practice, it has become sort of a license for federal regulators to rewrite statutes wholesale, to reinvent them in their own image, to make them do whatever the regulator wants. Now, this would be fine if we were talking about a lawmaking body, a group of elected senators and representatives who had the power to make law and also had accountability to the public, who could change out personnel from time to time if they didn't like the laws they were making. It's not okay when you're talking about a group of people who have been deliberately insulated from the political accountability that is at the core of our constitutional republic. The Separation of Powers Restoration Act would mitigate this harm and restore balance to the separation of powers by requiring courts to review challenges of federal agency actions afresh, or on the basis of what lawyers call a de novo standard. No longer would litigants come to the courtroom with scales already tipped heavily in the executive branch's favor, in the government's favor, in other words. This bill, to be sure, would not be a silver bullet. It's not a panacea that will fix everything. But it would be a solid first step towards reclaiming congressional power from unelected and unaccountable bureaucrats. Now, I don't want to monopolize our time here today, and I could talk about Chevron deference and Article 1, Section 7 all day long. So I'm going to turn it back over to you, Glenn, and I look forward to your questions and questions from the audience.